This computer. Okay, and then I will share my slides. Do this here and open a slideshow. And we'll say hello again and introduce myself again. So this is Michael Ladish, the Scholarly Communication Officer from UC Davis Library. I'm providing guidance and support and publishing, mostly open access publishing, also scholarly impact, and copyright. I'm responsible or working with folks on the Davis campus and on the Sacramento campus. So this is a workshop, a session presentation about copyright in relation to dissertation and thesis. So it's a little bit of a mixed bag. It will be a sort of a mini copyright 101 at the beginning to give you a little bit an idea what copyright actually is, what the copyright law covers, and so on. Then exceptions to the copyright law that are very handy and very helpful for your dissertation, but not only for that and for other purposes as well. And at the end, I will talk about embargoes, embargo policy at the University of California, Davis, and the UC in general. But before I go there, I have to bring in this disclaimer here. So I'm not an attorney. I do not provide legal advice. This is no legal advice here. Following information is to the best of my knowledge, and I try to help you as well as I can, provide guidance. But again, it's not legal advice. So let's start with the forms of intellectual property. So there are several different forms. Copyright is the one that we're talking about today. You are all familiar with patents. You heard about patents, but they are covered under different rules, different laws. This is something different from the copyright. Trademarks as well, it's another form of intellectual property. So trademarks like the Starbucks logo here, for example, this is protected. I cannot just open a coffee shop and call it Michael's Coffee and use the green circle and the mermaid and everything. That would get me in trouble with Starbucks. So this is protected. Trade secrets, the recipe for Coca-Cola, very, very strongly protected, and nobody should know about it. Geographical location is my favorite. Coming from Europe, there is a lot of, especially food and beverages that are produced in a specific region and can only be called can only be used the name of this specific region if it is really produced there. So several cheeses are from specific regions in Europe. The most familiar one probably is Champagne. So only the sparkling wine that is coming from the region of Champagne in France can be called Champagne or Champagne. And otherwise, you have to call it sparkling wine if it comes from Napa. So industrial design is another form of intellectual property. So they are all protected somehow under different laws, under different rules. But we want to talk about the copyright. The copyright law, the US copyright law, is in effect since 1978. This is quite a while, and I realized when it was passed in 76. So that was 50 years ago. So that's actually the 50th anniversary of this version. So this is a revision of the 1909 copyright law. So you can see this is not something that changes very often, but there are amendments that are introduced and implemented to reflect mainly technology changes. So there might be an amendment coming at some point to reflect the use of AI in relation to copyright law. a federal law. So this is this is a federal law. The copyright law is a federal law. So all suits are in federal court. There are state copyright laws, but they're not that many, and they're not as relevant for our purpose here. There are also, by the way, copyright laws in other countries, of course. So each country has their own copyright law, and they might be different. They can be significantly different, but most countries in the world have agreed under an agreement to honor each other's copyright laws, and also to sort of getting them a little bit in line, so that that things that are or products that are protected by copyright law here can be also protected in other countries and vice versa. So the copyright law was created to promote the progress of science and useful arts, as the Justice Sandra Day O'Connor said in a ruling. The first thing that comes to mind when you talk about copyright law, or when you think about copyright law, is protecting something from reuse, and only the copyright owner can give permission and so on. But it's not the primary objective, actually. The protection is an incentive for artists, for anybody who's creating copyrightable material, to create and then to make this material available so that others can build freely upon the ideas and information conveyed by that work. So it's an incentive, the protection is an incentive to create and therefore advance the progress of science and art. The subject matter of copyright, what is protected under copyright law? It needs to be an original work. So it needs to be really original, something new, of authorship. Needs to be an author, and I mentioned AI already. More recently, the Copyright Office, which is part of the government, put out guidance and said that material that is exclusively created by AI is not copyrightable. So the authorship really applies to human beings. This is important because more and more AI works, or works that are partially created by AI, hit the market in different areas, from scholarship to fiction to music and so on. But there's no final law, so the law doesn't say anything about it currently. There's lawsuits going on. The courts have to decide what is considered copyrightable and what not when AI is involved. So certainly a full work, a short story created by an AI tool is not copyrightable. But if you are using an AI tool to check your grammar or improve your grammar in a text that you're writing, that might be, the text is might still be copyrightable, but it's all a case by case. So, and this original work of authorship needs to be fixed in a tangible medium of expression. So it cannot only exist in your head, then it is not copyrightable. It needs to be written down, recorded, put on a PowerPoint slide. Even a letter is copyrightable. Any text that you type into your computer, photographs that you take, but it needs to be a tangible medium of expression. And then it could be different. It could be different categories of work. So literary work is this what comes to mind in the first place for most people when talking about copyright. And this includes scholarship, this includes academic work, this includes student essays, this includes conference contribution, this includes this presentation here, for example. And then, of course, literary work, poetry, and so on. Musical works, songs, compositions, anything you can think of is protected under copyright automatically. Dramatic works, including music that is included here, pantomimes, choreographic works, pictorial, graphic, and sculpture works. So this is all paintings, photographs, poster art, sculptures, or whatever you can think of. And then motion pictures, which is very complex in terms of copyright ownership, because so many different arts are involved to create a motion picture, from soundtrack to cinematography to script to directing to movie sets and so on. This is all copyrightable, but movie studios in general clarify this before they even start the whole process. And in contracts, it is clarified who's owning what and what the revenues are and so on. Sound recordings, very similar, can be very complex. You have the composition, you have the lyrics, and you have the recording, and it can be sometimes one of the same person. It can be three different copyright holders and architectural works. I have a little note here that's aware of layers. So copyrighted material in a photograph, for example, is still copyrighted. So if somebody is taking a picture of a sculpture, the photographer owns the copyright on the picture, but not on the sculpture. So if you want to use a photograph of a sculpture, then you might look into the copyright ownership of the photograph and of the sculpture. So these are different layers, and recorded music, the same thing I just mentioned that. So, but not everything is protected by copyright. So what is not protected? Anything, as I mentioned mentioned briefly before, anything that is not in a tangible, fixed in a tangible medium, so that exists in your head, like ideas, procedures, or even written down, like processing systems, concepts, principles. This is not copyrightable. This is not protected by copyright, regardless of the form in which it is described, explained, and so on. Facts are not protected by copyright. So if you measure the temperature every morning, put it in an Excel spreadsheet, that's not copyrightable because the temperature is what it is. There's a good example that I like to cite always from 1991, Supreme Court decision. This was a publisher in Kentucky, I think, who copied the phone book. So maybe you remember phone book. There's these big fat books that were in phone booths. You found at a phone booth. Maybe you remember phone booths. So they copied the phone book, and the company, the telephone company, who created this telephone book, sued them and said, "This is our copyright. You cannot just copy it and reprint it and sell it. This is our property." And this went all the way to the Supreme Court, and the Supreme Court then decided, no, this is not copyrightable. This is a list of facts, just the name and the address and the phone number. This is not something creative. There was no intellectual work involved to create this. These are simply facts that are put into alphabetical order. That's all they did. So it's not copyrightable. Words, phrases, familiar symbols, titles are not copyrightable. So the librarian, as a title of a book or of a film or something like this, that's not copyrightable. And there are multiple of such works that share the same title. You're probably very familiar with that. What is, however, copyrightable are characters, fictional characters. So Harry Potter as a title is copyrighted. so it's not the title that is copyrightable, uncopyrighted, it's the character. And I come to this in a second again. And then works by the US government is also not copyrighted. So whatever material they put out and put on their website, this is not copyrighted. And then finally, works of the public domain are not protected. And the public domain are creative works to which no exclusive intellectual property rights apply. And this is older material, so this is shifting as we move along. So now everything that is published before 1931 is not protected by copyright anymore. And then there was this phase between 31 and 1977 where copyright owners had to renew their copyright. If they didn't do it, if there's no copyright notice attached to the work, then it's also in a public domain. Then, this is the owner that failed to follow copyright renewal rules. Copyright owner are also able to place their material into the public domain. They can dedicate it. So let's say, no, I don't want a copyright of it. I want to have it available to the public without any restrictions. And then again, the US laws and government works and reports from this includes all the agencies, all the departments, and so on. Publicly accessible does not mean public domain. So I dedicated a specific slide to that because I hear this very often that, oh, it's on the internet. I downloaded it from this web page or from that website. When if you see something on the internet, it's more likely to be under a copyright, under protected by a copyright law and has a copyright owner than not. So it doesn't mean public domain. Some material that is publicly accessible can be reused. And I come to this also in a few minutes. Can be reused without permission. But very often material that you see online is copyrighted, and you can access it, you can see it, you can read it, but you need for reuse in a dissertation or a publication, so you might need permission, unless there are exceptions, but I come to the exceptions in a second too. So then we come to the duration of the copyright. So copyright's not endless. It is 70 years, the life of the author plus 70 years. So this was an act. This is one of the amendments to the copyright law, Copyright Extension Act in 1998. This was extended from 50 years after the author passed away, and it's nicknamed the Mickey Mouse Protection Act because at this time the cartoon character Mickey Mouse was about the copyright was about to expire. And so Disney and probably also with other film studios who had an interest in that lobbied Congress to extend this, and they did. Surprise, surprise. And now we have 70 years after the author passed away, or 120 years after the creation for copyrights that are owned by corporations like Mickey Mouse, for example. But the copyright on the character expired in 24, but only on the original cartoon and only the original Mickey Mouse. So they went through a number of changes over the decades, and today's Mickey Mouse character is protected again because it's not as old. So, and the copyright owner has exclusive rights for their work. Only the copyright owner is allowed to make copies of the work, to make derivative works based on the original, and derivative works in scholarly context is mostly translations into different language, but also abridgments, dramatizations. That applies more in fiction and literary works. Movie script based on a novel, for example, would be a derivative. Then exclusive rights for the copyright owners also distribute the work, to perform, publicly display, if it is photographs, paintings, and so on, perform for music, of course. But the copyright owner also may transfer some or all of these rights to others. And this is what happened, or what still happens, when you publish your work. So when you publish your dissertation as a book, for example, you sign a book contract with a publisher, and very likely they ask you to transfer the copyright to them. And so then the publisher is the copyright owner. The same happens with journal articles when you publish under the subscription model. The publisher wants to own the copyright because this gives them their exclusive right to distribute the work and make copies of the work, yeah, get the revenue for that into their pockets, with you getting royalties, in some cases for books, for journal articles not. So you can transfer the copyright on material to others. This in open access publishing, this is not the case anymore. So if you publish your journal article open access, you as the copyright owner, and you are the copyright owner of your manuscript, you retain the copyright. So this is not, the transfer is not required. It's not required because the publishers get an article processing charge or the open access fee, so they make their money that way. So for these are all the restrictions, so what you cannot do and what only the copyright owner is allowed to do. But there are exceptions. There are limitations on exclusive rights. And the most important one for us in higher education and research and so on is fair use, the fair use clause. There are other limitations and exceptions for libraries, for example, so we can create copies without permission for preservation purposes, for interlibrary loan. There are exceptions for people with visual impairments. They are allowed to create audio versions, which is also a derivative, what you normally could not do. But fair use is an exclusive, and a limitation to the exclusive right that allows you to use copyrighted material without permission of the copyright holder if certain if certain factors are met. It's mostly available, or you can mostly use reproduce copyrighted material without permissions for purposes as criticism, comment, news reporting, and then important for us here, teaching, scholarship, or research. So if you use material that's copyrighted for that purpose, then this is already a big plus for fair use. But there are other factors that you need to take in account and in consideration in order to decide, yes, I can use this material under the fair use clause. I don't need permission to that. And the four factors are, so it's the purpose and the character of the use, including if it's commercial nature or non-commercial. So if it's non-commercial or non-profit, then it leans more towards copyright. If the reuse is for commercial purposes, it leans more against it, but it's not clear cut. So there are exceptions on both sides. So the purpose and character, again, for scholarship, research, and so on, that's very, very much in favor of fair use. The nature of the copyrighted work, this is mostly unpublished versus published work, and this is the least important factor. The amount and substantiality of the portion used in relation to the copyrighted work as a whole That is important. So there are no red lines, bright lines in how much you can use or cannot use. There's sometimes people talk about, oh yeah, you can copy like 20% of a book, or you can copy like 10 pages without problem. That these are numbers that people made up, so it's not in the copyright law or anywhere else. It's really the portion that you use in relation to the copyrighted work, and also in relation to what you want to do with it. So if you have, if you are an art history and you have a painting that is copyrighted, and you want to show it your students, and you want to analyze it and discuss it, then of course you need the whole thing. You cannot just use a portion or 20% of a photograph or a painting. That doesn't make sense. Same as for a short story or a poem, for example. If you in English, if you work in English or do your research in English. It's of course different if you have a textbook and you want to use. You certainly cannot copy the whole textbook, because this would extend or exceed what you are allowed, and exceed also usually what you need to make your point. And then the fourth one is the effect of the use upon the potential market, the copyrighted work. So this again, coming back to the textbook, of course, if you copy the whole textbook for your students and distribute it in class, then this has an effect on the market for the publisher, because students wouldn't buy this textbook anymore, or the library wouldn't buy it. Or so anyway, so this is something that needs to be in consideration. Does the use of the material, the portion that I use for my purpose, does it have an effect, a negative, usually a negative effect, of course, on the potential market for the copyright holder? Do I cut into their revenues when I use this material the way I want to? So, and there's no, the fact that a work is unpublished shall not itself bar a finding of fair use, if such finding is made upon consideration of the above factors. So always think about these four factors, apply them to the material that you want to use for your dissertation, for a presentation, for a publication, or other purposes. And make the decision whether you can use this material without asking the copyright owner for permission or not. So fair use is really is your best friend. Without fair use, all copying for any purpose would, without permission, would be infringement, would be copyright infringement, and not allowed. So this is a really, really important exception of the copyright law. I mentioned already the other some of the other exceptions. So it's really important for teaching and learning. Fair use is also intentionally vague, because which can be frustrating. So it's very hard to tell sometimes. Yes, this is fair use, this is not, because at the end of the day, a judge would have to make the decision, say yes, this is allowed or this is not. It's intentionally vague, but because every single case is different, and there cannot be put any rules in place. There are no quantitative limits or absolutes. I mentioned this already. So it's a sliding scale of four considerations. No one factor is deciding. Every case is different. This is a nice brochure that the Author Alliance published for fair use for nonfiction authors, or scholarly publisher, or scholarly authors. Also, Authors Alliance is a nonprofit organization that helps and guides authors through the thicket of copyright and other laws. So they say yes. So apply the 4 factors. They are you're usually good fair use when it's when you use the material for criticism, commentary, discussion, and so on. Use it only to support or to prove an argument or a point. So use only as much as you need. Don't use more than that. Don't use it, and then it goes further down to make sure that you don't use it decoratively or to entertain. So then you get into an area that is not necessarily protected by the fair use clause. If you not use it for making your point. So yeah, make sure the amount that you copy, the amount that you use is reasonable, appropriate for the analytical purpose. And always, this seems to be a no-brainer, but I should mention is it always give attribution to the author of the material. That is hugely important. So fair use doesn't mean it's that material is it's available for grabs and nobody needs to pay any attention to who created it. So always cite the author, cite the source, and make sure that everybody knows that you use this material, that you got this material from the specific places. I mentioned open access publishing. So when you publish open access, publishers ask you usually to provide or to select a Creative Commons license. These licenses allow others to use this material without explicit permission because it is open access. It can be downloaded, it can be reused, it can be copied any way you want. There are some restrictions on it depending on the license. So you see on the right-hand side the icons and the logos for the specific restrictions. So some material can be are not allowed to be used in a commercial purpose, or only non-commercial. Other material or copyright holders do not allow the reuse in a derivative. So you will need to get permission if you want to do this, and you have and the SA you share it the same way as you as you use the material, or the same under the same license as the material is that you used. So you can combine these licenses. If you see anywhere the CC Creative Commons, you are already good. So this is for reuse purposes. That's even better than fair use because the license is really applied and tells you can reuse this material. You don't need permission. So that is very, very helpful. That's mostly in open access publishing. So now, if there's no Creative Commons license attached to the material and you think fair use might be a stretch, I cannot really use this material under the fair use clause, or also sometimes the publishers that you send your manuscript to, they ask you for permission for an image, permission for other material that you obtained from someplace else. So you can obtain permission, of course. You can identify the copyright owner. You can write them. It can be very almost informal, I would say. So there's a link to a template, and if you Google permissions for copyright, template, you get millions of hits, and you can select the one that you like. So you basically ask, I want to use your image, put a link to it for my article that will be published in journal X, and then you send this to the copyright owner. For many publications, the publisher is the copyright owner, and the publisher representative can point you to the copyright owner. In scholarly publishing, if it's not the publisher, if it's published open access, you just write to the corresponding author. For photographs, films, music, and so on, the copyright owners are often represented by licensing agent who would grant permission. They very often charge a fee, simply because these professions make their living. So professional photographers, musicians, and so on, this is their livelihood, so they probably ask for a fee. Yeah, you should also keep copyright layers in mind if an article an image in an article that you want to use might have a different copyright owner. Yeah, so there's a list of the things that you need to include in your permission letter, the exact nature of the use. And then you get an answer or not. So if the copyright owner is unresponsive, this happens sometimes, then you need to check for fair use option. Can I use it under fair use? Or use other alternative material. That could be frustrating sometimes if you really need this particular image and the copyright owner is not responding to your request, then that brings you into kind of a predicament. Equally, if the copyright owner can't be identified, so if you don't even know who the copyright owner is, and we have a lot of works in the library we call orphan works. So these are books by publisher, by authors. The authors have passed away. We don't know who the estate is, who the copyright owner is, where it was handed over to. The publisher might be not existing anymore, so it's really difficult to, and sometimes impossible, to find out. So here the case for fair use is stronger if you can demonstrate that you made a reasonable effort to identify the copyright owner, but you were not successful. But also you might think about using alternative material. So, and now I come to the ownership of material, the copyright ownership of material that you create. So everyone who is creating something is automatically the copyright owner. This is under the US copyright law. So you don't have to do anything. The manuscript that you write to submit for an article, your dissertation, the photograph that you took from your last trip to Yosemite, it's automatically protected under the copyright law. In the university setting, the University of California has two copyright ownership policies to make it clear who owns the copyright. And one is for course materials, and one is the copyright ownership on scholarly works created at the University of California. And there's a link that brings you to this page that explains what is protected under copyright, or what you as the creator of a work retain as copyrights, and what is the copyright of the university. So the creator of a work, of a scholarly or aesthetic work created by academic authors using independent academic effort, the author retains the copyright. The author is the copyright owner, not the university. Course material, same thing. The instructor who creates the course material owns the course material. That's not always the case in other institutions, not necessarily, but the University of California is. Personal works, okay, this is outside the scope of employment, makes sense. And student work, so this means dissertation, thesis, student essays, whatever. It's your work. The university doesn't have any copyright any copyrights on this material. But other works that are where the copyright belongs to the university are institutional works created by UC employees within the scope of their employment. And so my presentation here, that's a little bit of a gray area, because it's between my employment and my own scholarly work or effort. But a more clear-cut example is a designer that we have employed in the library. So we have a designer who creates signage and images and graphs and all kinds of things. That would be his copyright if he would be a freelance designer, but because he's employed as a designer, automatically in his contract, all the work that he creates as part of his employment belongs to the University of California. And this is then by extension, it's the regents of the University of California. They are always cited as the copyright owner. You can see this in many websites of the university. At the bottom, it's copyright regions of the University of California. So then sponsored works, commissioned work. So if the university hires a photographer, an outside photographer, to take pictures of graduation ceremony, normally the photographer would be the copyright owner if he would do this independently, but because the photographer is hired, he or she would sign a contract with the university where it's really clear cut and that so the copyright to these photographs are belonging to the university. So I don't want to go into more detail here because I'm looking at the time also a little bit. So copyright registration, yes, you can register your copyright with the US Copyright Office, but you don't have to. Again, the copyright exists immediately after something is created and available in a tangible medium. It needs to be original and needs to be a work of authorship, so you don't have to do this anymore, unless you sue for infringement. So that is probably the main reason that people register a copyright is if somebody infringed your copyright, used the copyright without your used the material without your permission, you can sue the person. But if you are not registered, or if you registered, then you can also, if you win the case, you can get attorney fees and statutory damages, because otherwise it's only real damages, and this is much harder to prove. The copyright registration goes through the US Copyright Office, which is part of the Library of Congress. So there are currently, I think there's some efforts underway to separate them, but I'm not quite sure where they are at the moment. They have a website. It's pretty straightforward. They charge a fee, and you get a certificate, and then you're registered. You protect your copyright through a copyright notice, and you keep track of it. Now this is relatively hard cut here, moving to the dissertation and thesis workflow. So when you file a dissertation and thesis, then it goes automatically to ProQuest. So this is, you're probably familiar with it. It's a database for dissertations. They have other databases as well, but ProQuest Dissertation is the one where the dissertation goes to. And from there, it goes automatically to eScholarship, which is the UC institutional repository. The ProQuest dissertation database is only available to subscribers, so most big academic institutions have a subscription, but not all of them, and smaller ones don't have it, and people from outside academia cannot access the material, cannot access the dissertation. But on eScholarship, it's available for everyone at no cost, so in open access, basically. There is a UC policy on open access for thesis and dissertation. So unless you put in an embargo, it automatically goes to eScholarship without your permission. You get you sign when you file, you sign that you acknowledge that. And unless you add an embargo for a number of different reasons, if you added an embargo to your dissertation, then ProQuest will honor this embargo, and the full text of the dissertation will not be available, also not to subscribers, as long as the embargo is in place. And the same applies to eScholarship. So you will see the citation, you see the abstract of your dissertation, but you don't see the full text. If you want to change your embargo, and I put the slide specifically in because I get this, I wouldn't say weekly, but relatively often, requests to extend the embargo because I want to publish my my dissertation or parts of my dissertation, or I have other reasons that I want to extend the embargo. Then the author needs to contact Graduate Studies first and fill in a form and get a signature from the major professor. If the embargo is exceeding 6 years, 6 years is the limit for UC Davis, then it needs approval by Graduate Council, and this is really an exception for things where dissertations that have content that might endanger people if they will be identified by putting the full text of the dissertation online, for example. This is something that they grant, but they are very, very strict. It's not just because you feel like I want to extend it and I want to keep it behind the embargo. So you need to have really a reason. Once it is granted, then you need, as an author, you need to contact ProQuest. They will also then change the embargo, and you need to request the change, the extension, also for eScholarship, and that's me at the moment as the eScholarship liaison at UC Davis. So you send me an email, or Graduate Studies usually send me an email already and request the embargo, and we put this in place. This both ProQuest and eScholarship are doing this relatively quickly in a couple of days. So I'm at the end now, and I will stop sharing, and I will also stop the recording.